The following is paid advertisement and does not reflect the opinions of this station. The choice of a lawyer is an important decision and should not be based solely on advertisements. The information presented in this program is general and is not intended to be legal advice and should not be relied upon or used without consulting a lawyer to consider your specific circumstances.
Questions about law, stories from the courtroom, cases that might impact your life. It's time for Tell Me I Have a Case with Dan Grimm and Matt Glenn from Cook, Barkat, Ponder, and Wolves. Find them at cbpw-law.com. Here's Dan Grimm and Matt Glenn.
Good morning and welcome back to Tell Me I Have a Case, the show where we ask you to take a second look at the world of personal injury litigation. I'm Matt Glenn of Cook, Barkat, Ponder, and Wolves, alongside one of my law partners, Dan Grimm. How you doing today, Dan?
Fantastic.
Yeah. Good weekend?
Oh, it was a great weekend. We went to the Shipyard Festival, and I'm telling you, it surpassed all my expectations.
Yeah, that's what I heard. It was good.
Man, the bands were fantastic. The setup, the ambiance, the atmosphere down there at the casino, it was just top notch. I can't wait till next year.
Yeah. All right. Well, maybe next year I'll make it.
I highly recommend it.
I heard good things.
It's a gem here in Cape Girardeau.
Yeah. Well, we want to unveil something new on the show this week. We want to hear from you. If you have a question that you want read on the air, or if you want to call into the show when we tape it, you can contact my direct line at 573-708-7105. That's 573-708-7105. We'll give that number out a few times during the show. Call, leave me a voicemail. Maybe I'll even answer. And we'll get you on the air, or we'll get your question on the air and try to get you and our listeners at home an answer. So today we're going to talk about one of the things that make litigation go, one of the most important parts about a case, and that is discovery. It's one of the parts that our clients are most active in, and one of the parts really to have the most questions about. It is, I think, incredibly important to begin this process early, and Dan, tell the folks why.
So, when we talk about discovery, written discovery is the first thing both sides see once litigation's filed. We propound to opposing counsel for the defense what's called interrogatories and requests for production of documents, and they send us like things to us that they want questions answered and documents produced. Well, as you can imagine, these things go back and not only at the time of the injury or crash, but they're asking questions that stem back 5 or 10 years, or maybe even longer sometimes, to involving our client's past history. Well, the importance of starting litigation, or the importance of starting this process way before litigation, is because, as you know, people have a lot of things going on in their life, and they may not remember exactly what's going on, and it takes time to kind of delve into their day-to-day activities, their history, their medical treatment, prior injuries. And the earlier you start the process, the more accurate you can be with that information.
Yeah, we found that a lot with witnesses, especially. I mean, you might remember an accident pretty clearly a year after it happened to you, but the person parked behind you might not remember it quite as clearly because it's not as important a life event to them.
Right.
And a lot of times if you come into our office early in the process, we can go ahead and talk to that witness, maybe get a recorded statement from them, figure out what it is they're going to say to sort of help us evaluate your case more effectively. One of the other things, you talked about going back 5 to 10 years. In what sorts of ways do insurance companies want to go back that far with our clients?
Sure. What we most commonly see is they want to know about pre-existing injuries to the body part that's at issue in this case. Mm-hmm. Meaning, if you injured your back or your low back or your neck or your shoulder, they want to know if you ever had any complaints at all going back typically 5 years. Sometimes they'll push and want to go back 10 years. And in some situations, it may warrant it to go back further. But as you can imagine, our clients have lived a ton of life in those time periods, and they may not immediately recall a prior complaint.
Yeah. And tell the folks at home, I mean, is it a big deal? Or what does it mean if somebody, say, had a neck complaint treated with a chiropractor 8 years ago and then didn't have any other issues for 8 to 10 years before a car accident? How often do you see something like that, and what's the importance of it?
Sure, and we see it all the time because people, that live, any adult's always had a prior something. I don't care what it is. You've had a prior sore neck or a prior sore ankle or a prior sore back. And what it means is that, somewhere along the line, you might have went to a chiropractor, or maybe you went to your primary care physician and they prescribed you some medication, but then it went away, and you didn't have any treatment for the 8 years or 5 years or 4 years leading up to this car crash or this injury.
Right.
Well, that's, I mean, indicative that whatever that prior complaint was, it wasn't a big deal. It was sore for a couple of days and went away. But that's important for us to know so that we can properly put in context what that prior complaint was.
Yeah, the most important thing we tell all our clients when they come into our office is the one thing we need from them is the absolute truth. We need them to tell us if they treated for a neck problem, 10 years ago, because if it did resolve, or even if it didn't, we need to know exactly what you did to treat that, whether you're still treating it at the time of the accident, and that way we know what your best case is. I tell my clients all the time, I can fix anything but a lie, right? If you're not truthful with me and not truthful with the other side, that looks horrible in front of a jury, right? It's my client's job to give me the truth. It's not my client's job to make the truth look good or bad. That's my job, right? I make the case for our clients. I just need my clients to be honest, good and bad facts about how they're feeling, how they were feeling before the accident, and how they're feeling after. And then it's up to me to make the case out of that.
We talked about the reason why it's so important to start this process early is because a lot of times the client is not intentionally lying. And most often, I mean, I would say 99% of the times they're not intentionally lying. The reality is they just forget. They don't think about it.
Right.
And then that's the reason why we say let's start this process early, way before litigation ever starts, so that we have time to go through, month by month, year by year, treatment by treatment to know exactly are we completely answering this question correctly.
Right. Instead of blindsiding them with a question of, hey, did you ever have a neck problem before? You sit down and talk with them. Okay, any other neck issues?
Right.
Going back years. I mean, let's talk about 5 years ago. Any issues with your neck? 10 years ago? 20 years ago? To kind of get them thinking about it.
That's
so it's
right.
not just, oh, I don't think so. It wasn't hurting the day before. A lot of my clients think that, well, I wasn't hurting, the week before the accident. Therefore, I don't think I did. No, I didn't have any problems beforehand. But you need it. You got to help them go through it step by step.
Absolutely.
Now, in terms of, you mentioned written discovery. What exactly is written discovery?
So written discovery is a series in the state of Missouri of 25 questions that essentially we send to the at-fault party. Typically, it's a truck driver or a driver of a motor vehicle crash. And we send questions to them, questions we want answered under oath. And they typically do the same thing. They'll send us questions to us that they want answered, questions that they're interested in that involve our client, our plaintiff. And they're answered under oath.
And when do you start that process? When a client comes to our office, when do we start answering those interrogatories?
So what I typically do is that we have a set of form interrogatories that we go through the client from the beginning when they come into our office, so that we can way before a lawsuit's ever filed. That way we can start gathering evidence that we know, or gathering facts that we know that the other side is going to be answering if litigation is filed. And so we started early, again, because we want to get into the history of the client that they may not readily remember. But if a lawsuit's filed, once we file the lawsuit, we often will send out immediately the interrogatory questions to the defendant or defendant corporation or defendant driver with another document called Request for Production of Documents that we'll send to the other side as well. Once they get served, the insurance company that hires the law firm to represent them, they'll typically immediately send a set back.
Yeah, and when they send that set back, if we've started early, we've already got most of those answered.
Correct.
It takes a minimal amount of time to get them answered. One of the things they're always asking for are plaintiff statements. They want a statement from the plaintiff as early as possible. We've talked about that on previous shows, that many times within a week of the crash, the insurance company is contacting you to take a statement from you.
Right.
And we're always telling our clients, look, that adjuster has taken 1,000 of these statements. You've never given one, right? And you owe it to yourself to come in and sit down with a lawyer to prepare you for the types of questions you're going to get, because it's hard to know what those questions mean. That's a huge part of the discovery process.
A huge part. Huge part. And one of the questions we always ask is our client, our plaintiff, provided any statements to anyone? The reason why is that we want to know what you said, if you said it, if you made a recorded statement to somebody, or you said something to somebody at the scene of the crash. Because a lot of times those statements can be taken out of context.
Sure. And many times our clients don't remember making a statement at the scene, and maybe they didn't make that statement. Right. I've seen plenty of police reports that have things written down that we know can't be correct. because we know our clients couldn't speak at the scene of the accident. They'd be airlifted out or something like that.
And that's one reason we always recommend to clients. I mean, if an insurance company calls you, simply don't make statements.
Right.
Come to us. That way we can sit down with you before and go through the facts of the crash, facts of your injuries before any statements are given.
Exactly. Another big thing that they're looking for in discovery and that we look for as well are photographs. Now, part of that's easy. There are photographs of the scene. There are photographs of, the dents to the car, the damage to the car. And many times there are photographs of you as you're treating, or the client as they're treating. But one of the biggest sources of photographs, and something we definitely wanted to talk about in this segment, is social media. That has been one of the biggest game changers in litigation, is social media. Dan, what's your advice to a plaintiff who's been injured in a car accident in terms of social media?
So I just think that social media is just, if you're involved in a car accident, simply don't get yourself involved in social media. I just think that it's not helpful. And so my advice would be, if I had my druthers, is simply stay off social media.
Yeah, entirely. That's my advice to clients too. And the reason is, I don't know anybody who lives their entire life on social media. It seems like all the friends I have on Facebook are doing great. Right? Right. There's absolutely nothing wrong with their life.
Always
they have
smiling.
It conquered. They're smiling. Their kids are high achievers. The spouse loves them, and they never fight. And they go on these amazing vacations that I can't fathom how anybody goes on. And they just have all this wonderful things going on in their life, and nothing ever goes wrong. And of my Facebook friends that I see on a regular basis, I absolutely know that that's not the case. Right? Like the rest of us, they have things going on that they don't put on Facebook. The problem is that if you project a certain image on Facebook, the defense will use that image and try to say that's your whole life. And so, unless you're willing to drop the camera on you, Truman Show style, and live on it 24/7 to show them how you really are, stay off of social media. It many times can be used by the other side to paint an inaccurate picture of you. Or at least an incomplete picture of you.
That's exactly it. And because that's exactly it. I couldn't, you said it perfectly.
Yeah. I have had, clients in the past, and I've had people when I was on the defense side, I would find things on Facebook that weren't even on their Facebook page. I would get their Facebook page, and I would look at it, and there'd be absolutely nothing there after the accident. And then I would check where they worked. And suddenly, there they are. I had one who was doing a dance on top of the bar, in the middle of the bar during a shift. Now it didn't look good for her because she says she's injured, but there she is, jumping up and down on top of a bar on a Saturday night. That wasn't even her social media. That was her work social media. So it doesn't just apply to your social media. It applies to your friends, your spouses, your neighbors, your kids. You never want to present an inaccurate picture of who you are and how you're doing, and social media is probably the number one way our clients run afoul of that.
Sure, because that picture takes a second to take a photo of that, but it doesn't reflect what you lived like 23 hours outside of that picture.
No, it doesn't, and it doesn't reflect the consequences of what you're doing in that moment. It doesn't reflect how you feel the next day. It's not a complete snapshot of who you are.
So, and that's what my advice is. Anyone that's involved in any type of injury or trauma or motor vehicle crash, simply just stay off Facebook. A lot of people want to Facebook about the crash or Facebook about what's going on. Just don't do that. Do it because, again, it could come back to haunt you.
Absolutely. So you've been listening to segment 1 of Tell Me I Have a Case, the show where we ask you to take a second look at the world of personal injury. We want to hear from you at 573-708-7105. You can call and leave us a voicemail. We'll get your question on the air. I'm Matt Glenn with Dan Grimm. Stick around for segment 2.
Cook, Barquette, Ponder, and Walls are very proud of the results they obtain for their clients, but you should know that past results afford no guarantee of future results, that every case is different and must be judged on its own merits, and that the choice of a lawyer is an important decision and should not be based solely on advertisements. And now, back to Tell Me I Have a Case with Dan Grimm and Matt Glenn.
Good morning and welcome back to part 2 of Tell Me I Have a Case, the show where we ask you to take a second look at the world of personal injury litigation. Alongside Dan Grimm, I'm Matt Glenn. You can find us on the web at www.cbpw-law.com, or you can contact us. We're inviting you to call the show I'm giving my direct line straight to my voicemail, 573-708-7105. That's 573-708-7105. Call, leave us a message. We may get you on the air to ask your question, or we might just ask it on the air and give you and the folks at home an answer. Today, Dan, we've been talking about discovery and why it's important to start it early, and we touched on it in the first segment. We're going to go a little deeper into it now. But prior medical records, that's a huge part of written discovery. And so what sort of prior medical records will be relevant in discovery?
Sure. The prior medical records that were relevant would be prior medical treatment or records that deal with the body part that is at issue in a crash. For example, so if you have an injured spine or neck or low back, and you had sometime 5 or 10 years prior, that could be relevant. And the reason why we always say, you heard us talk about it before, it's important to get us involved in your case early after a crash, is because a lot of people, the day of, they'll file a claim with their insurance company, and the insurance company will then notify the at-fault party's insurance carrier. Then the plaintiff will start getting forms in the mail from the insurance companies. Mm-hmm. In this stack of forms is always blanket medical authorizations. What I mean by blanket is that they're not limiting the time period to 5 or 10 years prior to this crash. There's no limitation at all. So essentially, they can get your prior medical records all the way back from the date you were born till present.
Right.
And we always limit that. We limit authorization to the body part at issue, and we also limit to a reasonable time period. But you'll see these authorizations, unfortunately, unknowing injured victims will just sign it, which you're giving medical authorization to people that can get any and all medical records that they don't deserve.
Right.
And you also see with employment. I mean, in the stack there'll be employment authorizations.
Right.
And again, they don't deserve your employment records. You have a right to privacy those documents.
Yeah, I think of every reason you've ever been to the doctor before, and you rightfully so have confidentiality with your doctor. You can talk to him about everything that is going on, or her, everything that is going on in your life as it pertains to your health, and you don't need to share that with a liability insurance carrier. It's just not relevant. And so you want to be very careful about what you're signing right after an accident. You mentioned employment records. You might have the type of a job where you don't need to miss work because of a car accident. They don't need to know what type of employee you are. They don't need to know about the time you got crosswise with your boss or filed a complaint because of sexual harassment. That's just not relevant. And that's part of your life you can keep private, provided you don't sign the wrong documents.
That's right. And they just mail them to people people unknowingly sign it. And a lot of times, thank goodness, people will come in immediately after the crash and they'll already have these documents not signed. Yeah. And I'll point to them and say, see, this is what they're trying to ask you to sign. It's a blanket authorization that they're not entitled to get.
No.
And so thank goodness, by clients coming in early, we can stop those type of shenanigans.
Yeah, and it doesn't mean we don't give an authorization to the insurance company. We want them to know what has happened to you in this accident, but we'll give them one that narrows the focus down to the parts of your body that are injured in this crash.
Exactly.
Right? And we'll narrow it down to if they want pre-existing records, we'll narrow it down to the 5 to 10 years prior to this crash. They don't need to know what happened to you during the Reagan administration. Right. That's simply not relevant.
Right. No. And for those people who don't know about the Reagan administration, how long ago was that?
That was at least 10 years ago. If memory serves, I wish. Then I'd be, a lot younger than I am.
Right.
But yeah, it's important stuff. And the point we drive home, and it kind of is a theme running through our show, insurance companies are good at this. They do this all the time. They have thousands of these claims, and this is your first one. If you have any questions at all, that's why you want to contact us. And not every client is someone we can help. Not everyone has the type of injury that we can really help them with, or get the type of value that would then warrant paying our fee. But we'll at least answer a few questions for you. We'll at least point you in the right direction, and kind of get you set to where the insurance company, maybe you want to level the playing field, and that's what really we do for our clients.
Yeah, it doesn't cost you anything to call on it, and if you don't call, it can unfortunately cost you everything because it can destroy your case.
Yeah. You're listening to Matt Glenn and Dan Grimm, Tell Me I Have a Case, the show where we ask you to take a second look at the world of personal injury. We are asking our listeners to call in with questions, 573-708-7105. That's 708-7105. We'll get you on the air, or we'll get your question on the air and answer it, but we definitely want to hear from you. One of the things they're always asking about, and this can be a really important part of discovery, are injuries that occur after the collision. What are some of the things you've seen in that area during your practice?
Sure. And part of what this discovery process is modern day litigation is not trial by ambush. So we have a responsibility to what's called seasonally update our interrogatory or discovery responses to the other side, and they're required to do the same. Well, as time goes on, unfortunately, people may, get in an accident 6 months, a year, 2 years after their initial accident that were involved in litigation. And so we're required then to notify through discovery responses that there was another collision and then about those injuries. And the reason why is that people want to see if the injuries in the second crash somehow affect the injuries that were in litigation for in the first crash.
Right.
And that's the gist of it.
Yeah, and we see this from time to time, and it's one of those areas where we tell our clients, you be as honest as you can with us. What happened in the first crash? What happened in the second crash? How'd you feel after the second one? Because they're going to know about it, right?
Sure.
It's going to come up, and we want to be as honest as we can about it. And again, our clients are not worried about trying to make the facts look good. That's our job, right? Our clients are simply reciting them.
And the reason why we talk about that is because sometimes clients, I think, are afraid that somehow we're going to be disappointed in them if they come in and tell us about a second crash. And that's not the issue at all. We just need to know everything, the truth about everything, and let us take care of the rest.
Yeah, that's exactly it. They also ask about other prior accidents or other prior claims and lawsuits. Another area that our clients think, oh, gee, I had this other claim. What is that going to do to this one? Well, if you ask us and tell us, then we can tell you. Why does opposing counsel ask about other claims?
The reason why is they want to essentially mitigate the injuries from the crash that they're involved in and blame everything on something that's pre-existing or prior. So if you had a prior crash and say again you injured your back or your neck, they want to say, well, everything was from that prior crash, not this crash. We see that happen all the time. The problem is if again clients sometimes don't want to tell us things, or they feel like they tell us, we'll lose faith in their case or confidence in their case and be disappointed. Mm-hmm. Everyone has some kind of prior injury or prior motor vehicle crash. But the worst thing is that if you don't tell us, we don't know about it.
Right.
And again, when you're answering these interrogatory questions, or you're under oath. Mm-hmm. And the big deal is that if we don't know about it and we can't properly put the most accurate answer down, the insurance company's going to know, or the attorney's going to know, because they have claims research databases that they can search your name and search accidents. Then now they're going to peg you as a liar.
No, and I tell my clients all the time, I can fix anything but a lie. Right, I can help you with anything, but if you lie to me, I can't help you there.
That's exactly it.
And I have fired very few clients during my practice, but the number one reason that I've done it is if a client has not been honest with me.
Right.
I don't have time to represent that. I don't have time. I've got other clients who deserve my full attention, and if you're not going to be honest with me, I can't help you.
And the thing is that everyone's got a prior motor vehicle crash or prior tickets, or they've gone to a doctor and had a prior sore neck. I mean, that's nothing to worry about. It's like I said, everyone, that's just part of living life.
Yeah.
But the idea, like he says, that we need to know the honest truth and accurate truth, so that way we can fully represent you.
Yeah, well, we were talking about this beforehand. I went and treated with a chiropractor for a hip problem I was having 5 years ago. He and I worked on it together. He took a couple of X-rays. We did some therapy, and it got better. And, since that's happened, I did a road race circuit with you last winter. I hiked at Philmont. We did 89 miles backpacking with 60 pounds on my back up and down some mountains for 10 days straight. I'm okay, right? I mean, that hip is fine. I don't have problems with it anymore. If I get in an accident tomorrow and the doctor tells me, wow, you messed your hip up, it's going to have to be replaced, the insurance company is going to pull those prior records. But the only way they're going to hurt me is if I lie about them,
Right.
Because I've obviously done some things, and I've got documented proof that I've done those things. The hip was fine, a week before the accident.
And that's exactly it. I mean, so by knowing about that, if you were in litigation, we could point to, you had a prior sore hip, or you treated for it, but obviously your hip is completely fine because look at what you've done since.
Yeah.
As opposed to if you try to hide that fact, now it looks like you're being dishonest and you're lying.
Yeah, and I can tell you what, Right now, as I sit here, I can't absolutely tell you if that was my right hip or my left hip.
Right.
You know, and if I come to you, Dan, to help me with this car accident that I'm not in yet, I would hope that you would get authorizations, go back to the doctor that treated me, and figure out whether it was my right hip.
No,
or left.
I've often said it too. You're not alone on that. I've told clients too. Like if somebody started looking at my past medical records or asked me off the cuff, tell me about all your treatment in the last 5 or 10 years, I might be 20% accurate.
Yeah.
That's why it takes time. We always talk. To name today's show is that we wanted to start this process early because it takes time to go through that. And it doesn't make the person a bad person.
Yeah.
It makes them human.
No, all of you listening out there, you might think you have a great memory of everything and how it happened. Ask your spouse if you really do, because I can promise you they have a different take on almost everything. One other area they always ask about that people don't like to talk about is they will ask for your criminal history. You know, it is one of those things they can ask about. It's often not admissible. It's only admissible in evidence very, very early on. You know, we just ask that you disclose it all, and typically speaking, it's the sort of thing that doesn't even come in. It's in front of a jury.
Right.
Yeah.
Right.
So the last area we talked about how you don't want to present a snapshot on social media. The other area that defense counsel or defense insurance companies will often engage in is something called surveillance. They will actually hire a private detective who will actually come out and try to videotape you doing things that a hurt person they think might not be able to do. How often have you seen that during your practice?
It happens. It comes up time to time, and I think for my clients, it's the most part of the process where they feel the most violated.
Yeah.
That someone has watched them from across the street or down the block or following them around. It's a very oogish feeling. But the idea is that, I mean, that this is, again, most people are living their lives one moment at a time.
Yeah.
And it's something that we tell clients not to change your life at all. But the idea is that them trying to get a snapshot of what it looks like from you walking from your front door to the mailbox is not indicative of what the other 23 hours of your life is like.
Yeah, I've there've been times in my life where I've had some pain in my legs, or had been told by a doctor you really need to rest. And I understand that I need to, but I have 2 kids and I have a wife that works, and there are times when I've been injured that I need to actually, I need to just get this done. This has to be done right now. It can't wait. My kids are screaming and yelling. My wife's going crazy. I need to just do this, and I'll pay the consequences of that. If I were to be photographed during that little snippet, yeah, I'm doing it. Yeah, I can get it done. But he's not going to videotape me limping out to the car the next day because I can barely walk. And that's what these surveillance people do. They will oftentimes spend 30 or 40 hours following around our clients, and then they'll videotape them for 5 minutes. One of the things I've done in deposition with them is I've highlighted that fact. You spent 40 hours following my client, and you got 5 minutes that you think are useful to your side of this case. I mean, 5 minutes out of 40 hours.
Right.
That's it.
Right.
The other 39 hours, in 59 minutes or 55 minutes, they're actually not doing something productive. There are huge limitations to surveillance, but it's one of those things that you really need, as you talk about your injury, that, there are things you absolutely can't do, and there are other things that you do from time to time, but you pay the consequence for.
That's exactly it.
Yeah.
Most clients fall in that category is that these injuries affect the quality and joy of doing, but they have to do it because people have responsibilities and families to take care of.
Yeah, your life goes on. You've got to continue to work to a degree. You've got to continue to provide for your family.
You just do it in pain.
You just do it in pain. So you've been listening to the Discovery episode of Tell Me I Have a Case, the show where we ask you to take a second look at the world of personal injury litigation. For Dan Grimm, I'm Matt Glenn. Please reach out to us if you have any questions at 573-708-7105. We'll get you on the air, or we'll get your question answered on the air. Thanks for joining us. We'll see you next week.
You've been listening to Tell Me I Have a Case with Dan Grimm and Matt Glenn. If you have questions and need answers, contact Cook, Barquette, Ponder, and Wolves today. Just go to cbpw-law.com. See you next week for Tell Me I Have a Case. The choice of a lawyer is an important decision and shouldn't be based solely on advertisements.